Live from SABC headquarters in Auckland Park, Johannesburg. Welcome to this Tuesday edition of the Watchdog. My name is Vuyo Mvoko, and on the show tonight, police unable to curb runaway gender-based violence numbers, a new report released today shows. We speak to the report's authors. Chapter 9 institution, the Commission for Gender Equality. Civil society organizations unhappy with social development proposals gazetted yesterday on the 350 Rand social distress relief grants. They tell us why.
I hereby inform the Honorable Court I'm withdrawing as the Council of Accuse 1 to 4.
And before we end the program, we get our regular legal expert to weigh in on the dramatic exit of defense lawyer Malisela Tefu from the Senzo Meyiwa case. That and more coming up in tonight's episode of The Watchdog, which starts right now. A new report released today paints a rather grim picture of the police's inability to deal with gender-based violence. Launched earlier today in Johannesburg, the Commission for Gender Equality report highlights serious capacity constraints as a major contributing factor to the police's inability to curb the rising tide of gender-based violence in our country. The report was compiled by the Chapter 9 institution from a series of oversight visits to police stations in various provinces and areas that are classified as GBV hotspots. Advocate Ntabiseng Sepanya Mohale is a commissioner with the Commission for Gender Equality and joins us now on the line. Good evening, Advocate. Thank you very much for your time.
Good evening, Vuyo. Thanks for having us.
Well. Another report, another rather grim picture of the situation. Never ends, doesn't it?
No, it doesn't. It doesn't.
Tell us why you felt the need to do what, I mean, apart from the fact that you have to continuously, have these oversight engagements to familiarize yourselves with the situation. But was there another reason this particular exercise had to be done?
You spot on, Vuyo. The first reason is the fact that it is our mandate to oversee all government and private society formations to see if there is work towards gender equality in all forms. And as you know, one of the biggest challenges that we have impeding gender equality in our country is violence against women. And when there was the hotspots police stations, we actually thought, let's have a dipstick and put it in the situation to check how grave the situation is. And if it is not grave and it's improving, what are the strengths so that they can be filtered to other police stations, that certain things to be strengthened and upheld. What actually is the situation? We wanted to know this, and the best way was actually to go to the hotspots that the police had already identified, link them to all the key areas of GBV. One of the key areas beside the police station, as you know, where interdicts are issued, etc., would be your Tutuzela care centers. It would be your courts, where there are specialized courts as much as possible linked to the Tutuzela care centers, where women can go and report, or sexual violence cases can be dealt with in a sensitive and empathetic manner. So that's how we started.
Yes, the situation is grave, but did you find that it was perhaps better or worse than you thought it would be?
Unfortunately, Vuyo, it is worse than we thought it would be. Worse in the sense that some 30 years or no, just slightly under 25 or so years ago, the government started a focus into the issue of violence against women, and so much resources have been put into that area, and we one does not see the impact thereof. There aren't any dividends that are coming, but over and above the dividends, the situation is not even at neutral. It's getting worse. There's more violence that we're seeing. There's more violent incidences of abuse that we're seeing. There's higher levels of femicide now that we're seeing. And just horrendous crimes against women that are becoming the norm in South Africa. So it is getting worse.
Now, I mean, among the things you found, as you said, was a general shortage of vehicles, for example, in responding to cases of domestic violence in particular, massive delays in uploading DNA cases. I mean, both of these issues, I mean, there have been calls for both these issues to be addressed. I think there's a general acceptance, one, that there isn't enough money or that enough resources out there. And there is also, I think, generally speaking, an acceptance, that not all problems will be resolved at the same time. But one often asks whether often the issue is not really so much about resources, but prioritization, and
Yes.
in other instances, simply not caring. Why am I raising these two issues and in the manner that I'm raising them? It's because if something like what happened in Soweto happens, right, then all of a sudden you have a dozen cars being made available. Then you ask yourself, but where were these cars, before this particular incident? Do people care about these PR exercises more than thinking proactively about how to address the challenges that we all accept exist? Okay. Probably problems of load shedding there. I don't know what happened. It would seem like that, in fact, is the case. We are going to try and redial Advocate Sipanya Mokhale to get her back. Yeah, she has indeed been load shed. We're going to take a quick ad break. Our conversation with her continues on the back of that report where they visited classified GBV hotspots across the country to look at the situation there, and they found the situation to be worse than it actually was. We were, of course, going to go next to what then they're going to do about what they have found. That conversation continues right after this. Well, we are still hoping to get Advocate back to continue with that conversation, but we're battling to get hold of her. So we're going to continue with our next story. Hopefully, we'll be able to get back a little later on. But to this now, in a government gazette published yesterday, Social Development Minister Lindiwe Zulu is proposing that it be those who earn 664 rands per month or less who must now receive the 350 Social Relief of Distress grant. The sum of 624 per month has been set as the national poverty line by Stats SA. The revision of the qualification criteria became necessary, the government says, once the national state of disaster ended in April. Regulations implemented in April reduced this figure to 350, resulting in less spokespeople qualifying civil society organizations have been critical of the government for both this move and for the delays in processing payments. The public has now been invited to make written submissions on the new proposal gazetted yesterday. Now, Ariella Sher is with the Center for Applied Legal Studies. They represent the Black Sash Trust, which together with several other organizations have been challenging the state on this matter. Good evening. Thank you very much for your time.
Hi, Vuyo. Thank you so much for having us on.
Okay, let's start with the revision first. Do the new numbers make sense? Do you like what you're saying? I'm talking just about the figures now.
So just to confirm, so the Center for Applied Legal Studies on behalf of the Black Sash Trust has instituted litigation on the basis of the current regulations that are in force. The new regulations that have now been gazetted are in fact an amendment proposal.
Yes.
So we take issue with what's currently in force, the 22nd of April regulations.
Well, now that there seems to have been an improvement, is that welcome, or are you still having issues?
So,
If the newly gazetted were to then be enforced.
So that does meet one aspect of our case and our challenge to the current regulations. We took four issues we took issue with four aspects of the regulations. So one of them is the lowering of the threshold, but there were two problems with that. The first was just the fact of the substantive lowering of the threshold. We believe very strongly that government needs to be providing for the most vulnerable people, and that those are the people that have been getting the grant up until the end of March this year.
Okay, we'll get to the other ones, the other three, if my calculations are correct. But sticking to the first one of the amount for a second. I don't know if you've done similar exercises to those that were done by your IE Institute for Economic Justice, for example. If you remember right from the start when, everyone got the ball rolling on this issue. There were issues of, no, it's not affordable, everything from the social relief of distress grant to a, well, let's put that aside so as not to cloud issues. Let's stick to the social relief of distress grant. Do you know, or are you aware of anyone who may have crunched some numbers and said, this is what would be both ideal and at the same time affordable? Well, we've been stuck there, in the past 2 years of the toing and froing on this matter, including, of course, the basic income grant, which we're not talking about today. Yeah.
So I guess I'm a bit lucky because I'm a lawyer. I'm not an economist, so I don't
so
have
get
the
away
numbers
with not
for you.
answering that one.
Well, what our case focuses on is what the legal obligations of government are. It's up to government to meet those, at very least the minimum legal obligations. And then it's up to them to find the necessary budget for those legal obligations. So what we say is that those legal obligations oblige them in terms of the right to social security and social assistance in the Constitution. It obliges the government to provide for those at the very most vulnerable layer of society. And we suggest and we believe very strongly that meeting that minimum basic poverty line level is that meets the government's obligation. So when they lowered the threshold effective from the April 2022 regulations, we believe that was violating the government's legal obligations. And also another problem is that it was rolling back on something, a constitutional right that had already been provided for. The government's not allowed to do that. That's called retrogression. The government must act progressively, and you can't take away rights that have been given to people, particularly at that most vulnerable level.
A very important principle. Let's talk then about the other three areas that are of concern to you.
So what I will note is that the second area that we take issue with in our case is also purportedly addressed in the amended draft regulations that were released. And that's the fact that what the government had done in the regulations is say that regardless of all of the information that an applicant for the grant gives to SASSA, they're going to look at bank verification information and they're going to privilege that. So It doesn't matter what the other information says, they're going to go with the bank verification information. We don't think that that's appropriate for this cohort of persons. So we take issue with that. In the amended draft regulations, the government's removed that step.
Well, I mean, it was quite interesting. I mean, last week we had the executive manager, I think he's called, in the department, who is specifically responsible for grants. And I asked him why they were reliant so heavily, on what the banks. Because if you remember, when people started asking questions about why there were delays, it was because, in the conversations with the banks, we were not getting the kind of cooperation we thought we would get. We're still negotiating, and because of the nature of the relationships that we have, this matter still has to be, and so on and so on. So, I mean, it is a problem, I think, for a lot of people. In fact, we went further in our conversation, where I said, from some of the people who were giving us, feedback, there are people who take care of siblings or who send money to one family member so that they can then help support the family, while the breadwinner or winners are in Johannesburg or Cape Town, and some people are either in rural areas or some of the townships across the country, to which then the executive manager said, look, we are aware, or become aware, that there are shortcomings with how we have approached this up until now, but we're trying our damnedest to try and address that. I don't know if you accept that, or what it is that will convince you that they are indeed now aware of that, and indeed are prepared to do something about it.
I think the issue with the bank verification has a couple of aspects. So the first thing is that when the grant was initially established at the beginning of the COVID pandemic, what the government was doing was, or what SASSA was doing, was it was relying on its internal databases, on the state's internal databases. So it was looking at information in UIF records and SARS records, and not realizing that the cohort of people who are requiring 350 Rand to help them eat and live, that cohort isn't really, their lived reality is not consistent with what probably outdated SARS and UIF databases are saying. So the government came in, and our understanding is they then tried to amend that and say bank verification might be a better indicator. But as you're saying, I mean, or based on what you're saying, that's only exacerbated by the fact that government hasn't been paying grants since the end of March. So how much more so now people are asking their relatives, their friends, anyone that can assist them to transfer them even 100 Rand, even 200 Rand. Over since April, May, June, we're now into July. Even if you were getting 150 Rand for each of those months from wherever you could get money from, you've now met the threshold. If the government looks then at your application and looks at your bank account, they're going to see you're above 350 Rand and you don't qualify for the grant. So it all ties into quite a problematic system that the government established in the April regulation.
In fact, I mean, we went further in our conversation last week, where I asked him whether he could vouch for their system generally, and then secondly, whether in light of all the objections, or people who were, that they declined, whether their appeal process, or their system, in fact, takes into account the fact that there's now an appeal process. In other words, if you resubmit, can their system say, oh, okay, no, this is now a resubmission, and therefore we can, but of course you continue to say, yes, there may well be room for improvement, but generally speaking, he could vouch for their system. But other than what we've spoken about, are there other areas of concerns or red flags that you may have identified?
Yeah, so what you've said actually leads into our third point, which is that in that appeal system, and this has been a problem since the advent of the grant, that both the Centre for Applied Legal Studies and the Black Sash has been submitting comments and letters to government about, that in that appeal system, if I'm rejected and then I go into an appeal process for the grant, I can't submit new documentation, new information. So if I submitted my application in February and they're only assessing it now, my circumstances might well have changed, because we know that most people who are collecting the grant are sitting at that level of society where they're in the informal sector. So it's not a regular salary that they're getting, and within 2, 3, 4 months, their financial circumstances will have changed. And so we think it's problematic that rejected applicants can't submit new information or new documentation on appeal. So that's our third issue. Our fourth issue is then quite simply that this new iteration of the grant, you can only apply for it online. We think that's incredibly inappropriate for, again, the cohort of society that is applying for the grant and the realities of South African society more generally. Most people, even if they have access to a computer, don't have access to the data, might not have access to the electricity required.
Or they have the airtime. They may not have an Android that can then,
Exactly.
a lot of people still use the Dilili, they call it, which can
Exactly.
to make and receive calls. But of course, I mean, you will be making submissions.
I can't guarantee you that. Again, our case is on the current regulations. These are amended draft regulations. So we're still to decide, whether we're going to make submissions. We of course welcome them, but we note the length that this kind of process usually takes.
I mean, your clients have previously had sort of, contact sessions with representatives of the government where you've tried to iron out some of these things without necessarily having to go for litigation. So I'm sure those possibilities still exist, because, I mean, the longer these processes drag on, then it can only mean that, the designated recipients, of what we're talking about still don't continue to not receive what is meant for them. So those possibilities I would imagine still exist.
As a civil society, litigation is always the last resort. So we never rush to court. We always try to make use of those connections, engage with government, write government letters, and of course we did that in this case. And our client is still doing so, and we remain open to those kinds of engagements. But our main concern is for the grants that have been affected by the current regulations. If we are going to make these amendments, that the amendments be made very quickly and that they operate retrospectively. Every successful grant applicant from the 1st of April 2022.
Which they have committed to, yeah. But it's going to come in tranches because, and there were lots of explanations around this. Just lastly, I mean, is it for lack of trying on the part of the government, or is it just box-ticking exercise that to be seen to be doing something, perhaps grudgingly or reluctantly?
You know what, I won't pretend to understand what goes on in government. Our job is just to hold government to account. So as I said, we really try to do that through engagements, and where engagements fail, we go to court. So at the moment, that's where we are. We hope, and we would always assume good faith on the part of government, but we do still treat our role as holding them accountable very seriously, and that's what we consider ourselves to be doing here.
Okay. Ariella Sher, that's where we're going to leave it. Thanks very much for your time.
Thank you.
She's, of course, from the Center for Applied Legal Studies. They represent the Black Sash Trust, which together with other organizations have really been pushing on this issue, challenging the state's attitude or attitudes towards some of these matters. We'll see how this particular episode kind of unfolds. Up next, we're going to go back to that story we started with before our guest got cut off because of load shedding. Welcome back, and if you've just joined us, we were talking earlier about to Advocate Ntabiseng Sepanya Mokhala, who is a commissioner with the Commission for Gender Equality. Today, they released a report that paints a rather grim picture of the police's inability, I should say, to deal with gender-based violence. And we were busy talking about that when, of course, she got load shed, but thankfully, we've got her back. Advocate, what I was asking before we lost you was whether, sometimes one gets a feeling that there's a lack of planning or prioritization, because on the one day you'd be told that, we don't have these vans that can respond quickly, to cases, of domestic violence. But the next day there would be something happening at a tavern. Communities ask questions. The minister arrives hours later, and boom, suddenly there's cars available to be given to that particular community, which then begs the question, where were these cars all along when people were asking for them? And the question I was asking you was whether you feel that there is something, notwithstanding perhaps challenges that may exist, but there is also blame that should be laid, at the door of the authorities in terms of how they plan, in terms of how they prioritize, or whether they even care.
Vuyo, you are spot on. The issue of resources was amplified when we visited the Sasolburg police station, which is also a government garage, for a lack of a better phrase. We found more than 200 cars that were standing there in the yard that had been brought there to be repaired for one thing or the other. And we were told that some of the repairs were small, very small things, but you find that the car stands there for close to 2 years or even more.
There's horror stories. I mean, you and I fix a tire in a few minutes. Apparently, if it's taken to a government garage, it takes a good few weeks.
Yes. And the irony, or the painful irony, if I must add, of that was you had your Bobby on the beat police officers actually patrolling the town and the township by foot, which actually puts them at a very high risk of being attacked, etc. Sometimes they would use horses and all of that in that area. But it's actually painful. In one police station, which acts as a government garage in the Free State somewhere, there's more than 200 cars that are parked, that as a result, as you say, of poor planning, they are there and either they're not being paid for the repairs, or nobody's coming to fetch them, or nobody's dropping them off. They don't know who dropped them off. It's just poor planning and poor prioritization. A second example of poor prioritization is what we find again in the Free State, where you have there was a good cohort of forensic nurses that had been trained. They're all retiring now, and you have just a few of them still remaining. And every time they go, they're not replaced. So you have the same team of forensic nurses working in a huge region. For example, your Welcome, Virginia, Lijueli Putsa kind of region. You have 4 or 5 nurses. Can you imagine if they have to be going to all those clinics? They get to a clinic sometimes after 3, 4, 5, 6, 7 days. And at that time, one wonders what then happens to the women who have been violated, who are told, please, as much as possible, preserve the evidence, so that when a forensic nurse examines you, etc., you are there's able to be more evidence that can be collected, and then a surer situation of a possible conviction. So the cases are actually lost before they get to court. But it's that poor planning and prioritization. Why are we not getting new nurses? Why are we not training people to specialize? Now we've got an added situation that was never there 15, 20 years ago, where the doctors are delaying to fill in a J88. A J88 is a tool to gather information as you are examining, at the point of examining. But guess what? Now we have doctors say, come after 3 days to collect it. I'm too busy to fill it in. How will they remember your injuries? How will they remember the unique features of your violation? You know, all those kinds of things. So a J88 has now shifted from becoming a normal tool that a doctor fills in at the spot on the table as they are examining you. It has become something that they fill in sometimes after 2 weeks, even a month. It is frustrating. Then the last point that we picked up was that the rape kits are all brought to Pretoria still. 28 years later, we're still having our rape kits brought to Pretoria. So you have one car sometimes coming from a province after collecting rape kits in all of their police stations to take it to Pretoria. So it can take up to 3, 4, 6 months even of rape kits lying in a police station, let's say a Tabani or Ladybrand or whatever, waiting for the next trip when the trip is being made to Pretoria.
Which then brings me
serious problems.
Which then brings me to the whole, question of, much as your a report focuses on police's ability or lack thereof to deal with these matters, it's also about the justice system in its entirety, as well as the things that were built into it to make sure that it functions optimally. I'm talking about the role of parliamentary bodies like your select committees and portfolio committees. I'm talking about the role of your police secretariat, for example, because if other people's complaints are anything to go by, there's fingers to be pointed there as well. Yesterday, we were having a conversation here about, rubber bullets and what has been happening, the cases that have come before your IPID. And the experts we were talking about were also pointing at fingers at those oversight bodies, that if they were to get up and do their part, or play their parts, perhaps the situation could improve.
Yes, I think it would improve a great deal, especially the integrated oversight bodies, because it's one thing to have one oversight body monitoring alone. It's another if they were to monitor and see themselves as an integrated team. For example, it's pointless for SABC team or team of women and youth and people living with disabilities monitoring, because they are quite vigilant in monitoring, and then you have Department of Health not involved in that. So they do not understand the impact of lack of forensic nurses. They do not understand the impact of the poor quality of service that their doctors is giving. They do not understand that in their rooms, in a hospital somewhere, there's stacks and stacks and stacks of rape kits that have actually been used and are waiting to be collected. We do not know when. And as you know, rape kits involve live samples of evidence. So after some time, those samples go off. Somebody has got to be knowing that, no, as a forensic health practitioner, I'm actually supposed to expedite this. But what they will then do is, I did my part, I put it on the table for whenever it's coming to be collected. Whereas this is supposed to be seamlessly coordinated, somebody making sure that it goes. But why anyway do we have only one laboratory in Pretoria? Why can't we have 8 other laboratories? Considering the high levels of violence in our country, that is supposed to be a bare minimum in terms of service that will ensure higher conviction rate, that will ensure that the correct people are actually arrested and convicted, that will ensure that crimes are resolved. We've still got one forensic laboratory, Pretoria.
Let me end off by your own role now as a commission? I mean, you've been caught in all sorts of dramas, allegations of maladministration and poor governance, interference by commissioners in the running of the organization, infighting among commissioners, which has resulted in some of you being outside of the commission as we speak. What have you been doing to deal with those issues? Was there, frankly, a distraction?
Absolute distraction, Vuyo, you're right. Number one, I just want to clarify, there isn't infighting amongst commissioners. There has been commissioners who have been violated by a commissioner. So there isn't infighting. There's been a violation directed at nothing less than 6 commissioners by the one commissioner. We have then taken the liberty to report this commissioner to Parliament. The matter is seized with Parliament now. It's at the Speaker's office, where it was properly, information was gathered, preliminary evidence was done, and then it has been presented in the Speaker's office. In terms of the rest of the team at the CGE, it is intact. Secondly, we as commissioner members have got the duty to provide oversight. And Vuyo, where you have an organization that maybe is not used to oversight, people are usually being told to back off by saying you are interfering. That is a Chapter 9 that relies on people's tax monies. It has got to be accountable to the people of South Africa, not to individuals. We will make sure that that is achieved whilst we are still at commissioners at the CGE. That has got to be an institution that is responsive to every sector of our society in South Africa. It has got to be that, not only a particular sector. So it is branded out there as almost it is interfering. It is pure accountability, which we have got to make sure that that organization provides to South Africa.
So there's no truth in the allegation that some of you don't want or want the CEO out?
No, it's accountability. No, definitely not. That is why the CEO is still in the organization. But if you have a CEO who may not perform or who is performing, the truth shall be told in that regard. If the CEO is performing, the CEO will stay. If the CEO is not performing, then due process will follow. That will ensure that the CEO performs or, something gets done. It is an organization that has got to be accountable. You cannot have an organization that spends taxpayers' money and nothing to show for it. Truth be told, the impact of the CGE out there is still very, very limited. And I, as a commissioner, feel I've got to ensure during my tenure that that impact increases for the people of South Africa. Not for individual staff members, not for individual, a classic example is this study that we undertook to say, let us go out there and find out for ourselves. When the Minister of Police says there are 30 hotspots police stations, we went to 66 police stations to actually say, let's go and find out. We cannot be sitting in offices. And that is how that organization has got to be run. We hold hearings. We hold people accountable. We do investigations. All of those. That is how an organization is supposed to be run, not a talk show.
Okay, we're going to leave it there, Advocate. Thank you very much for your time, Advocate Ntabiseng Sepanya Mokhale, who is a commissioner with the Commission for Gender Equality. Today, they released a report on how police across the country are dealing with gender-based violence, and that report is unflattering, to say the least. Drama at the Pretoria High Court today after Advocate Malisela Tefu announced he is withdrawing as counsel of accused 1 to 4 in the Senzo Meyiwa murder trial. He told the court he could no longer take the harassment he alleged he was receiving from the state and the court itself. Griselda Lewis caught up with him immediately after the dramatic turn of events.
The justice system in this country is becoming a circus. You cannot put the innocent person in court. This is a winter. The poor guys were supposed to be at home. They are now dying for the sins that they don't even know. They never even committed. You see? So I cannot be part of this. I don't know what to call this. For the lack of the, for the lack of the relevant weight. Yes, I cannot seem to be justifying the injustice. So what is happening in that court of Maumela is injustice at all. The worst ever I come across. 12 years as a practicing advocate, Zozu. So I've never come across the situation in that way. Yeah, so every time for the accused 1 to 4, Maumela cannot be able to take a decision. But let the other one raise something. He's able to take a decision. So with only us. So now I realize that I'm becoming a burden to the lives of the poor guys there. You see, those guys are innocent. Yes. So now it's better now that I'm out. Then I think it's relieved. It's a relief. Even this morning, he said to me that he doesn't know which school I've attended. I think now you'll be relieved. But I'm not taking that in a hard way. You see. So
are you saying that the judge is biased in this matter? Is that what you're saying? Can you categorically state that?
I've got the instructions 7 times from my client, from those guys. Say, we see what judge is doing. Can you please bring the application? And I've always advising against that, to recuse him. Because I consider the application for recusal a cause of delay. Because according to me, this appearance here of these 5 guys is supposed to be preliminary. It was not even supposed to go more than 2 weeks. You see, there is a trial that should come of 7 people. They don't want us to go there. If this matter has been postponed to the 7th of December, and there is also the talk of the possibility of next year, where are we going? Where will these people ever get the justice? These poor guys. Will the Senzo Meyiwa get justice?
Do you think that there will be justice for Senzo Meyiwa's family? This basically takes the case and sort of throws it on its head.
Exactly, definitely my point. And then my reason for this, because like I said, we had a thorough consultation with Sfiso Meyiwa, you see, because as I'm saying that, this so-called trial of docket 636, the docket which people were arrested after it was quashed. When these people were arrested, the docket was quashed, was no more there. But now, they brought it to life because they want to protect somebody. You see, people who were in that house where Senzo was killed, that house is treated like a national key point. You see, if the parliament in Cape Town was named after someone, the lady in that house, that Cape Town parliament could not have been on ash because that name of this lady is so protected. It's a national key point. So her name is protected more than the national key point.
For some perspective on what today's turn of events could mean, please welcome a regular on the program, and that's Ntavi Singh. Ntavi Singh, good evening. Thanks very much for your time. I don't know what you make of what advocate there, was arguing.
Well, I actually didn't see this interview in this afternoon, so it's the first time that I saw it. And I'm not sure what it is that he was trying to get across. But I do understand from what, when you look at the history of this case, that there has been issues where the presiding officer, Judge Maumela, and also the DIFO, where there have been a lot of procedure, where procedure wasn't being followed, and certain things were being said, and as I just mentioned, procedure wasn't followed in those things being alluded. So be that as it may, I think the main contention today was the issue of the fact that he wanted to lay the basis for this letter that he had for it to be heard before the court today, and this was not canvassed by with rather his colleagues, which is Advocate Mshololo and Advocate Baloyi, wherein they were basically bamboozled to say that here's a letter pertaining to the conditions that my client is now living with in prison, which is all well and good. But if you had received that information prior to coming into court rather today, then what ought to have happened was, at minimum, if you got it yesterday, then maybe scan and send it to the other parties, Advocate Mshololo and Advocate Baloyi, and also send it or try and converse these issues with the head of prison before coming to court. So when you come to court to seek help in this regard, all parties that are concerned have been informed of this, and then the court can say, okay, seeing as you have spoken to all parties and the head of prison is present before the court, then maybe we can hear what the best way forward would be.
He had a duty to do that.
As always, yeah.
Now, what if, and I'm posing possibilities here, I mean, obviously don't know the facts. By the time the events of this morning happened, he was already on breaking point. In other words, things had gotten very bad, certainly from where he sits, that it was just the last nail in the coffin, so to speak.
It seems that way. Saying the words to the presiding officer, the words that you are accused number one in this conspiracy that is happening in this matter, shows his frustration. But I think if he had given it a chance, the directions that he was being shown by the presiding officer, that, all right, I hear what you're trying to say, and I hear I can see the road you're trying to go onto, but in order to get there, this is the trajectory that you need to follow. This is the line and the route that you're supposed to follow. And instead of taking it so personally, because when Advocate Mshololo and Advocate Baloyi would stand up, they would be of one mind. And then it seemed as if they are ganging up against him. Whereas it's just another way of saying, Advocate Tipo, this is where you're supposed to go. It's an indirect way of showing him the way forward. But it ended up being what it is today, which is very sad, I must say.
Yeah, because that's what might be my next question, that how much of a duty does a lawyer have in such circumstances? You put your interests, your ego, your frustrations first. What about, as he claimed, the interests of the people he represents? What about the people he's going to continue to represent, because he'll have that watching brief on behalf of the brother, What does a lawyer do in such circumstances? What trumps, what becomes more important?
You always have to be as impartial as possible as an attorney. No matter how frustrated the system gets to you, you must remember that the objective at the end of the day is to represent your client to the best of your ability. So if you're going to have issues with the way things are being done, what would we usually do is that when the matter is adjourned for whatever day or whatever the case may be, then we just meet up as colleagues, including the presiding officer, and say, wait, can I just understand why are we, why is this seemingly a bias against me, and all of that, air out any issues that seem to be there. So when we go back into court, we go back with an understanding on how to proceed with this matter. But, you have to always keep your client's interest ahead. It is allowed for you to terminate mandate if there's conflict of interest, or if there's other numerous reasons why you would want to terminate mandate or withdraw as attorney of record in this regard. But what you would do is then lay those conditions or reasons to the court and say, because of reason A, B, C, and D, I do not feel I can proceed with this matter. And then with leave of the court, may I then be allowed or permitted to withdraw as an attorney of record? And then the court will then say, based on the reason that you're putting.
Is that not what he was trying to do right at the beginning when it started, which some people have referred to as a tirade?
Well, I don't think so. I think he was trying to try and throw in another aspect of the case. He didn't exactly lay down what it is that his issues are.
Okay.
What he did say instead was say that, okay, as a result, I'm resigning, so to speak. I'm just withdrawing as a tenure of record because you are being biased. What he ought to have done was say, you know what, my lord, throughout this matter, 1, 2, 3, 4 has happened, and as a result, I feel like I, in my personal capacity, have not been afforded the opportunity to represent my clients properly. But the manner in which he decides to do his matters, or rather address the court in this specific matter, is the one that ends up getting him in hot water, and then he ends up thinking that no one is listening to him. I do believe the things that he says actually make sense. It's just that the sequence of events, or rather the procedure that should be followed, is what is missing. He could most likely win this case, but it's just that he is not willing to accede to how criminal procedure ought to work in this matter.
Lastly, and very, very briefly, and I'll be saying, potentially, what could this episode now mean for this case?
So now the accused persons have to be reread their rights. So they need to decide whether
Okay, and Tabiseng's line, not playing ball at this critical moment. I'm afraid that's where we're going to have to leave it. And Tabiseng Duazano, of course, comes on the show quite often to clarify these intricate legal matters for us. But that's where we're going to leave it for tonight. Do enjoy your evening. And please come back. Join us tomorrow night, same time.